The discussion yesterday and today concerned EU law in terms of directives, case law of the Luxembourg court, and state relationships and so on. Today, Roundtable has been dedicated to the contrary to international law and to comparative law. On the side of comparative law, the organizers have chosen 3 countries, USA, Brazil, and China. And of course, it's a matter of treating 3 big countries with very different problems, of course. In USA and Brazil, the legal system is a federal one. In the United States, of course, the problems are in terms of internal relations, which are formulated usually in terms of commerce laws, while in Brazil they depend on a kind of committee clause in a more flexible way. And China will hear our guest. The situation, as far as I know, is quite static. I read that 6 or 7 big cities have started to apply some experimental measures, but no concrete state initiative has been carried out up till now. So I prefer to give the floor immediately to our first speaker, Professor Janet Mile from Vermont Law School. She's an expert of environmental taxation, and I see that she has always been also been a clerk with Justice Coffin and assistant to Senator Benson. The floor is to you.
Thank you very much, and thank you all for staying. I know that lunch is on the horizon, so I appreciate your willingness to listen to this panel. And Marta, I join the long chorus of people who have thanked you. It was extraordinary of you to put together this project and be able to obtain the funding. It's already produced 1 book, it will produce another, and it's produced these fascinating 2 days. And to Javier for all of the work that he's done along the way, including the trials of bringing me in by Skype for various different workshops, which is not always easy. So thank you. My task this morning is to just briefly talk about the U.S. perspective on these issues and how it compares with the EU's state aid rules. But I thought I'd start with just kind of a few thoughts about why the comparative law perspective could be useful for this discussion about the EU state aid rules. And there's the basic reason that I think it's instructive to think about how others approach the similar problems, just to get the wealth of knowledge on the table as we think about various alternatives. But also, I think with energy tax incentives, there's more cause because we're dealing with climate change. So when we have international negotiations and when we're working on national implementation to try to meet our emissions targets, it's helpful for us to have a better understanding of what our legal capacity is to use tax incentives to try to achieve our environmental goals. So the legal framework in each of our countries sets the policy baseline for what we can do. In addition, I think it's even more important to think about these issues because we're hopefully heading into an international competitive race for the green economy. Which countries are going to be capturing the markets for new energy technologies and products? And in that context, it's again very important for us to know who has the power to use tax incentives to try to contribute to that goal and in what ways. What are the legal limitations that each one of us face and how do they compare with each other? So in the next few minutes, I'll just give you a very brief thumbnail sketch of the U.S. constitutional framework and how it affects the ability of the U.S. to use energy tax incentives, and briefly how that compares with the EU perspective, with the state aid rules. So when we're dealing with a comparative analysis, a basic question is which levels of government are we comparing? And one way to look at the issue is that we can compare the federal government in the United States with the EU at the supranational level, looking at the highest powers. And there, when we think about tax issues and energy tax issues in particular, we have a significant difference in the basic constitutional structures. The United States federal government has relatively unrestrained power to use taxes. So it has, within the US fiscal system, the federal government has 60% of the tax revenue for the country as a whole, about $3 trillion a year. So it has the capacity to harness its tax system for environmental and energy purposes. Whereas if you compare that with the European Union, as you know better than I, it at the union level is subject to restraints on the ability to use taxation, and in particular the unanimity rule. So that's a major difference. And alternatively, we could compare the federal government in the U.S. with the member states of the European Union, because they have the core taxing power in the Union. And when we do that, we again see a significant difference, because the member states, as we're all keenly aware, are subject to the state aid rules, whereas the United States federal government has no comparable restraint. As an example of that, the federal government in the tax code currently has an investment tax credit for wind farms, and that tax credit over the next 5 years will cost $15.8 billion. So that's a major subsidy to the wind industry delivered through the federal tax system. And you can think about whether that would be possible for states through the state, with the member states with the state aid system. But the third way to look at the picture is to compare the states in the United States with the member states of the European Union. And I think that's the most relevant comparison here, because they're all operating as members of a confederacy in what is a common market. And so in that context, we have the state aid rules that come into play, but in the United States, we also do have some federal controls on the extent to which states can use their regulatory authority and their taxing powers. So we have something that's somewhat similar to the state aid rules, but different in a number of ways. So that's what I will explore. And the plot in the U.S. for the constitutional structure that sets up this system goes back to 1787. So you see slightly different wardrobe choices than in Sebastian's 1951 photo a few minutes ago. This is a painting of the Constitutional Convention in Philadelphia, where the states came together to negotiate the form of this new country that they were creating. The states have the residual power, and so the question was how much power and what kinds of power would they give to the federal government in the Constitution. They gave the federal government the power to tax, but they also retained strong taxing powers themselves. They also reached the conclusion that the federal government should have the power to, quote, regulate commerce among the several states. Those 6 constitutional words. And we've come to know that in U.S. law as the Commerce Clause. So the federal government has the affirmative right to regulate commerce in order to protect the internal market among the states, now the 50 states. That's somewhat similar to a driving force in the European Union Treaty. You wanted to create a common market, and now it's a question of how that principle gets executed. So the federal government can pass laws that regulate the way in which interstate commerce is conducted. There was an interesting twist, though, in the mid-1800s when the United States Supreme Court said not only can Congress affirmatively regulate interstate commerce, but that same language, those 6 words, also means that states cannot pass laws that will discriminate against interstate commerce. So they can't do things that will interfere with commerce. And that's what's been called the Dormant Commerce Clause, because it's implicit in this language. This language gives the federal government the power, but the court says it also, in this quiet way, keeps the states from acting in discriminatory fashions. So that's the key element that comes into play when we have the question of to what extent can states in the United States provide aid for energy and environmental and other purposes. So with this Dormant Commerce Clause, how does it compare with the state aid rules? A significant difference is that the Dormant Commerce Clause, under the Supreme Court's current interpretations, does not apply to direct spending actions by the state. So states can give cash subsidies for energy purposes, a wide variety of purposes, and not be subject to this rule that they should not discriminate against interstate commerce, a major difference from what you have with the state aid rules. But the court has also found that the Dormant Commerce Clause can apply to tax incentives that states enact. So it does come into play with energy tax incentives. One example of that came up in a Supreme Court case involving the state of Ohio. So on this map, Ohio's in the eastern portion of the country. The state of Ohio had enacted a tax credit for ethanol. So every gallon of ethanol that was sold in the state and blended into gasoline to make a better mix was eligible for a tax credit. But the state said you only get the tax credit if the ethanol is produced in Ohio or in a state that has a comparable tax credit. That went to the Supreme Court, and the United States Supreme Court said that violates the Dormant Commerce Clause. What you're doing is putting the interests of the state over the interests of interstate commerce and discriminating against ethanol produced elsewhere. So that's an example of how this constitutional principle can limit the ability to use tax expenditures for energy or environmental purposes. The state argued that they were doing this for environmental benefit. Ethanol would have air quality benefits. The court did not accept that argument. It reasoned in part that ethanol in Ohio was just as clean as ethanol produced elsewhere, or was no cleaner than ethanol produced elsewhere, so it was still discriminating. So there's an opportunity to make an environmental public interest defense, but it's often hard to succeed in justifying when the discrimination is clear. So we have this principle that operates, and it is still, the parameters of the Dormant Commerce Clause are still open to some question. It continues to be litigated, so we don't know, there are areas of ambiguity where we don't know the full parameters. But to overly simplify, I think we can say that states have to be careful about when they're doing something that is going to be actively discriminating against interstate commerce in favor of their own activities within the state. So how does this compare then with the state aid rules? Procedurally, we're in the U.S. are in quite a different situation. You see here the words of the entire clause within which the Commerce Clause is contained. Very few words. And those words are interpreted and enforced by the courts. So this is entirely a judicial system unless Congress comes in and passes a law that preempts the issue through the use of its affirmative Commerce Clause powers. So this creates a judicially enforced system. It also depends on whether anyone chooses to take an issue to court and whether they have standing to do so. So you may have things that happen that go unchallenged and violate the clause, but they just never get litigated. So procedurally, simple language that hasn't changed since 1787 and is interpreted over the course of the centuries by the court. By contrast, you have the state aid rules where you've got more detailed language in the treaty. You've got pages of material coming out of the European Commission, put in place through an administrative process. There's a role of the court in judicial review of actions, but you have the much more complex administrative procedures and including issues of ex ante and ex post notification or approvals. Substantively, there's substantial differences. I think in some ways the U.S. Commerce Clause allows for more freedom than the state aid rules. It's a general statement. It's interpreted on a case-by-case basis, whereas you're subject to very specific sets of rules and requirements through the block exemption and the other guidelines. So very different degrees of flexibility. On the other hand, the EU treaty recognizes explicitly the role of the public interest in offsetting that desire, that the inclination to discriminate. So there's a balancing between protecting competition and protecting the common interest. That's not as explicit in our case, and so I think it may, in some situations, make it more difficult in the United States for states that are discriminating to be able to justify the result. So we have two quite different systems, both motivated by a similar concern to protect a common market, but executed in different ways. So if we go back to the big picture, you see a federal government in the U.S. that has strong tax powers. You've got the state aid rules operating in the EU and Commerce Clause restraints in the United States on just operating at the state level. So our loose constitutional principle versus your tightly knit rules with potentially different outcomes for different situations. So in conclusion, I just have a fairly simple thought in this comparative analysis, and that is that constitutional divisions of power matter in the United States. They set the legal framework within which we are choosing our energy and environmental policy instruments, so that these constitutional powers will determine what levels of government can act and in what ways. And I think we'll see that these divisions of power give some countries more freedom than others to use a broader array of policy instruments, and I think that will become quite striking with the examples of China and Brazil. And finally, as we make these policy choices that are influenced by this framework, I think it's especially important to think about what our legal portfolio of instruments consists of as we increasingly are dealing at a national level and at an international level with the challenges of climate change and the desire to grow the green economy. Thank you.
Now the floor is to Professor Yan Xu, who is going to talk about China. She is director of the Center for Financial Regulation and Economic Development at the Chinese University of Hong Kong, and she has recently visited other universities in Europe like Cambridge and Linz and New York and New South Wales. The floor is to you.
Firstly, I also would like to thank Marta for getting me involved in this fascinating research project and for inviting me to this conference. It has been a privilege for me to be here to learn a lot from you in the 2 days conference. So today, my presentation will be focused on the case of China. I will talk about energy taxation and competition law constraints in the country. So firstly, the discussion of the relationship between energy taxation and state aid in the European Union, or similar mechanisms such as the dormant commerce clause in the United States, seems not a very serious issue or relevant issue in the case of China. There does not exist legal provisions or norms that require the government to balance the use of tax incentives and concessions relating to energy and the need of protecting the internal common market in the country. This is primarily due to the constitutional design of the state government and the legal institutions in respect of state power allocation and coordination in the country. I will explain this very soon in the later slides. Until now, China has not yet had any tax directly targeting on the environment and energy, but the Chinese government has made it very clear in recent years that it will use various measures, including the market-based instruments such as environmental taxation and emissions trading scheme, to deal with environmental protection and also energy conservation in the country. Moreover, some existing taxes that have a direct or indirect relationship with environmental protection have been used for purposes of increasing energy efficiency, reducing energy wastage, and also adopting new types of energy by way of tax incentives and concessions. The application of these tax incentives does raise issue with regard to the development of the market across regions within the country. So before we go to the discussion of energy taxation and the related issues on competition and competition law, it's necessary for us to look at the constitutional design of state powers in the country. First and foremost, China is a unitary state according to the constitution of the country. Article 3 of the Constitution clearly provides that all government institutions are under the uniform leadership of the central government, which refers to the government in Beijing. Local governments are the agents of the central government at the three local levels: the province, the prefecture, and the county. Where the central government exercises uniform leadership of state powers, the local governments have been granted a wide range of initiatives to implement national laws, regulations, and policies within their relevant jurisdiction. However, unlike the states in the United States or the member states of the European Union, China's provinces, with the relative comparable size of the European member states, do not have much autonomy in exercising fiscal and taxation powers within the provinces based on the constitutional design. In terms of taxation, the Chinese constitution does not provide any specific provisions directly relating to tax law-making power. The only article on taxation under the constitution is Article 56, which provides that the Chinese citizens have the obligation to pay taxes in accordance with the law. However, the essential question, what is law for tax purposes, is not very clear under the Constitution. The Constitution also contains no provision stipulating that the legislative power to enacting taxes should be reserved to the national legislature, which includes the National People's Congress and its standing committee. In practice, the national legislature, especially the National People's Congress, has dedicated the tax law-making power to the State Council, the highest executive body in the country, for quite a number of times. For example, the most important tax reform in modern times, the 1994 tax reform, was implemented based on the State Council delegation. In 2000, the law on legislation was promulgated by the National People's Congress, which for the first time provided clear rules restricting the delegation of the power to make tax laws to the executive body. The law was amended in 2015, last year. With the amendment, it is now very clear that only law should be enacted on the basic system of taxation, such as the establishment of new taxes and the determination of tax rates. On the other hand, Article 9 of the Law on Legislation still affords the legal basis for the State Council to exercise delegated powers to make tax rules and policies when needed, when necessary, notwithstanding the reservation article under the Law on Legislation. So put aside the question of whether the delegation is inconsistent with the rule of law, the tax legislative power is reserved to the central government, which is either exercised by the national legislature, the national legislature, the NPC, National People's Congress, or by the State Council, the executive body of the government. So it seems, prima facie, China has a very highly centralized legislative system. The local governments are limited in their power to make tax rules and policies. In practice, however, a different conclusion may be drawn through the examination of tax incentives provided by the local governments. During the last 3 decades, local governments have afforded a variety of tax incentives to foster economic development in the relevant local regions and to fulfill other objectives the local governments designed. Some of the incentives have gone beyond the boundaries of higher laws and regulations and cause harmful or unfair competition between different regions of the country. The central government, however, has been unable to supervise the use of those tax incentives by the local governments. So the de facto leeway for local agencies to interpret laws and regulations differently to provide incentives may lead to state aid, and that is that in the European Union at the local levels in China. China has joined the WTO in 2011. China also has concluded some regional free trade agreements with the relevant regional organizations and also countries. However, in general, the WTO rules and the regional rules on subsidy related to the energy sector have had a very limited impact on the domestic laws on taxation and energy. So because of the time constraint, I will just skip the discussion of this part. For domestic law on taxation related to environment and energy, the protection of the environment and conservation of energy has for a long time been considered a national policy, as evidenced by China's constitution. In recent years, given the serious concern about pollution and the worries about energy safety and security, the Chinese government has introduced many tax incentives to encourage the taxpayer to reduce pollution and reserve energy. So according to the State Administration of Taxation, the highest tax authority in China, there are 14 types of environmental tax policies provided at the national level, making around 6.5% of all currently effective tax incentives adopted by the central government. However, the provision of these tax incentives relating to the environment and energy are scattered in various tax laws and regulations and also policies. Despite the fact that environmental tax incentives have been widely used in China either by the central government or by the local governments, there is a lack of detailed rules regulating environment tax incentives, especially the rules on the use of tax incentives that may discriminate against internal regional trade or fair competition across regions of the country. As regards energy, unlike the European Union, China doesn't have a comprehensive energy tax system. Nevertheless, it has 2 taxes relating to energy that are resource tax, including the tax base of the resource tax covers salt and the mineral resources, including oil and natural gas, and consumption tax The consumption tax is a peculiar Chinese term, which refers to the excess tax that is implemented in elsewhere. For energy conservation tax purposes, the excess tax or the consumption tax in Chinese term applies to the use of petrol and diesel as well as vehicles. Moreover, there are two taxes on vehicles. The vehicle acquisition tax and the vehicle and vessel tax have an indirect relationship with the consumption of fuel. Given the very serious environmental problems in the country in recent years and also heavy pressure from international partners, the Chinese central government is considering introducing an environmental protection tax soon. As a matter of fact, a draft bill on such tax was released for public consultation in June last year. Under this draft bill, local governments are granted the power to adopt certain environmental tax incentives for environmental protection purposes. If this draft bill is finally adopted as a law, local governments could be given much discretion to implement the policy, which, without sufficient supervision by the central government, may lead to abuses of tax incentives in practice that impede competition across regions of the country. So to illustrate the use of tax incentives to the energy sector in the country and its likely consequences to the unified common market of the country, I did a case study on the practice in the 4 provinces, which are Xinjiang, Inner Mongolia. Inner Mongolia is not a province, but an autonomous region according to the constitution, Jiangsu province and also Guangdong province. The 2 regions are chosen because they are the representatives of regions rich in natural resources. The latter 2 are selected as representatives of regions with a comparatively developed economy. A number of tax incentives have been provided for the energy sector by the local governments through local rules in these provinces or autonomous region. So here is a brief summary of the use of tax incentives in these regions. Except for, as you can see from the table, except for the 2 local rules provided by Xinjiang government, all the rest of local tax rules provided in the relevant regions are aimed to promote the development of the new energy sector, especially the photovoltaic industry in the relevant regions. For example, the local rules provided by the Hohhot government in 2009 provides very generous local tax incentives to local photovoltaics companies, including the exemption from VAT on the transfer of technology and also the provision of research and development. It is worth noting that all the 6 local tax rules provide tax incentives through the mechanism of refund after collection. This is for the purpose to circumvent the prohibition on local tax incentives that go beyond the boundaries of higher laws and regulations implemented by the central government. Based on the tax law and also other related laws, especially the law on legislation, such a mechanism is illegal. In practice, some local governments have been using this mechanism in a very sneaky way, but because of the time constraint, I will also skip this discussion. In practice, the central government has made various efforts to crack down on the use of the mechanism, because this mechanism has led to some unfair competition across regions of the country. In practice, local tax incentives beyond the limits of national laws and policies will give a competitive advantage to the local energy industry and therefore impede non-local government energy products from entering local markets. The provision of such incentives can be regarded as a type of administrative monopoly disallowed under the anti-monopoly law. There are three types of administrative monopoly provided under this law. The law has defined the term administrative monopoly very broadly. So under the law, although there was no explicit provision forbidding the local governments or the central government from the use of tax incentives to restrict or eliminate competition, based on the broad definition of the term administrative monopoly, probably the term can be construed to cover administrative monopoly that have been created by the use of tax incentives by the local governments. So, based on the preliminary research, I have some conclusion, also a brief comparison between the case in China with that in the European Union. As we can see, currently there is no any principle or rule that is similar to the state aid in the European Union in the case of China. As compared to the European Union, the Chinese central government has unlimited powers, relatively unlimited powers, at least under the Constitution and the law on legislation, in terms of taxation and also the regulation of the energy sector. And the Chinese local governments are just agents of the central government. They have very limited autonomy in taxation. Even though in practice they may use local tax incentives to advance various local objectives. While by comparison, the European Union member states are independent sovereign states. They have unlimited fiscal autonomy unless the provision of any aid by the member states affects trade between the between member states in the European Union. And finally, I also have done some research on the cases related to the provision of state aids in the energy sector and in the European Union. And I can say there was a relatively developed jurisprudence on the relevant provision of state aid by the Court of Justice of the European Union. Well, in the case of China, there has been very few cases on administrative monopoly in China, and there is no any case on administrative monopoly in the case of the energy sector in the country. So the final question is there any need for the Chinese government to establish a similar regime of the state aid as that in the European Union, in the case of in China? China has a very different constitutional design and energy market. So probably there was no imminent need for the central government to introduce such a mechanism. But because China and the local governments have been implementing national laws very differently, or have been implementing national policies in a way that is inconsistent with the design of the central government. So probably there would be a case for the central government to step in and override local interpretations that may affect competition and also trade across the regions of the country. So that's the end of my presentation.
Thank you, Dr. Xu, for the interesting information about China. I dare say, summing up, that the giant is not quite dormant, more or less like the commerce clause. Something is moving, but we hope the pace can be accelerated. Okay. The floor is now to Professor Marcos André Viñas Catao. He is professor of taxation in the Getulio Vargas Foundation, and also lawyer in Rio and Sao Paulo. The floor is to you.
First of all, for sure, I'd like to congratulate again the organization of the event, both at individual and institutional level. First, individual, congratulate again Marta, Jerónimo, Pasquale isn't here anymore, but also the guys and the ladies that supported this event, Monica and Javier, the other ones. No, I have to say also, this is something very private for me, but this is a very emblematic situation for myself, because I did my doctoral thesis, I presented my doctoral thesis here at SEL, and for me, this is a very amazing situation, a very happy situation to be here among friends, some old friends, some new friends, and also here in Excel. But going straight to my presentation, I promise to have a non-Brazilian punctuality, but a British punctuality in terms of timing. But I'd like to make some remarks, and in my case, because I'm going to make some comments in relation to Brazil for sure, because I'm Brazilian. I have some knowledge in respect to other countries in the region, but I would prefer. Hello. So instead of making some specific comments about our systems and regimes, I prefer to invite you to do a more to go to a more conceptual approach on the issue. No, much have been said in these days about tax incentives. No, but when I've been invited to talk about tax incentives, state aids, or subsidies, I'd like to have this very fundamental difference of what I call regimes. No, in the book that Martha presented on Monday morning, we have one article from Gina, and we have these names to have this differentiation between regimes. No, a more liberal or a more conservative regime. I'm calling liberal the regime or the state or jurisdiction that has a very low level of control in terms of state aid, incentives, or subsidies. And for sure, a more conservative or more rigid regime, the one who preserves or aims to preserve a more united market. Why for me this so important? No, especially being a Brazilian. No. And we have a case where we have this approach in my country. No, sometimes, I remember when I was studying with Martha. No, Martha for sure is one of the most expert professors in terms of state aid. And in the first moment, I have this. No, how good is the state aid regime in Europe? But in the second moment, you see that you have also some deficiencies here in Europe, and then you go to the other side for a more liberal approach or regime. No, and then why this is important? Because you have a very strict or a very direct relation between incentives for undertakings, and we are here in a seminar about energy incentives for one specific sector or undertaking, which is the energy sector, and the flexibility of the system. No, why this is important? No, and why this is much more important when we are talking about the energy sector. No, and I briefly mentioned this issue yesterday when I posed a question to Pasquale. Because in the end, the countries they tend to be more liberal because they have natural approaches or natural peculiarities in their constitutions, and even in the geographic zone they are located. No, for instance, in the case of Brazil, because we are now again having this discussion, because we need to create a more consistent market in the country, we must have a more united market in the country, and so have to limit the tax incentives that are granted by the states. Brazil is a federal country like US, and then the states and also the municipalities, they are empowered by the constitutions to create their own taxes, and so we're having this discussion. No? And why this is worse, no, in the case of energy? Because, as I said yesterday, because the countries, they have a natural intention to protect their undertakings, their industries, especially in the energy sector. For instance, in Brazil, 80% of energy in Brazil comes from hydroelectrical plants. No. So for sure, there's a natural tendency to grant incentives in this field, or at least in this kind of energy. Argentina for a long time was exporter of oil, and Paraguay is also a big producer of hydroelectrical energy. So in the end, those countries, they try to protect their industries or their own energy sector by granting incentives. And then, in my opinion, this is a very complex situation to have a different approach in this country. In the opposite way, if you have a more liberal or a more conservative like you have in the European Union, as we were discussing yesterday too, in the European Union you have a lack of energy. In the end, the European Union is more dependent on energy than other places in the world. So it's easy to have a more conservative regime like you have in the European Union, because naturally you have a country or a region in the globe that is more dependent of energy. But again, so coming back to this difference, no? We have other elements on this difference. One of them is about, as I just mentioned before, that about federation, being a federation. For instance, in Brazil, we are a federation, Argentina is also a federation, so this brings a new complexity or another complexity in order to introduce a more conservative mechanism of control of tax incentives or state aid or subsidies. And then we have this option, no? Should it be more close to the United States? I know that Jenna made her speech about the dormant clause, but in my opinion, and for sure you have very good articles about that. There's one article, the work of Jenna for sure is precious, but you have a very interesting article of Ruvem Aviona comparing the Cuno case in Ohio with the state aid regime in Europe. But in the end, I think that the regimes, they have a natural tendency to go to one way or to another. So in Brazil now, I think because we are a federation, because we grant powers to the states, it's more consistent to have a more liberal system. And then, because you have a more liberal or more conservative, you have to regulate the system. And then you have to regulate the system through a procedure or a litigation system or more constitutional based on case law and other elements of the system. So, first part of my presentation, I'd like to have this introduction because, I mean, it's not a matter of having a good or a bad incentive, but it's different when you are in different regimes when you grant an incentive. No? So we have these two positions. In addition to that, and this was really important to me now, because I think that we have a third actor in this, or a third position considering these two approaches, the liberal and conservative. And this one could come from the WTO organization. Why from the WTO? Because the WTO seems to be an impartial body, no? Because you know that here in the European Union you have a lot of controversy, you have a lot of case law, but in the end the countries are the ones who grant incentives, and the countries, they are not impartial to analyze some state aids or tax incentives. But the problem what's the problem of WTO? And then the same when I was researching for my thesis, it was a long time ago, I was very seduced by the WTO, but again, you see the WTO is not perfect. Why is not perfect? Because mainly for two reasons. The first reason, the WTO, they have its own concept of subsidy. No, you have definitions very close to state aid, and for some extent it's very close to a definition of tax intensive in some countries in Latin America. But the problem that this can generate a juxtaposition between the decisions and the concept that is adopted by the WTO and other countries, or the internal legislation or the internal tribunals. Also, a reason of that is because in the case of the countries, what I want to say that the WTO could act as an impartial actor to analyze different incentives from different regions and to have a good position or to create jurisprudence in terms of legitimacy of those incentives. But why this is not possible? Because the countries or the jurisdictions or the systems, they have different approaches in relation to the WTO. And one of the most important issues in this scenario is about what's the so-called direct or self-executing effect of the WTO. And then we have difference. I can just give an example. In the case of Brazil, the Supreme Court in Brazil has ruled a long time ago that the decisions from the dispute settlement body and also the rules of the WTO has direct penetration in the internal legislation. Here in the European Union, the WTO legislation is considered to be a secondary rule and for sure cannot revoke or overlap the internal legislation of the European Union. So in the end, the WTO is not, I don't think that in this moment, for sure, we have to wait for the Doha round. I think that the WTO is a very important body in the moment, and it could be a very important actor to balance the concession of tax incentives in different locations, different countries. Going to my part in the end, that after this conceptual approach, to Mercosur and Brazil and tax incentives. What I can tell you in relation to the country Brazil, to the region South America, we are super liberal in terms of tax incentives. I want to say that every country grants tax incentives. We have a so-called tax war, which is in the end a tax competition. Not because we have this very open system or regime, but also because the two biggest countries in the region, Brazil and Argentina, they are federations, they are federal systems. And then because they are federal systems, you have a lot of incentives, not only at the federal level, but also at state level and the municipal level. By the way, Brazil is also a very complex case because you have three taxes on consumption. You have a federal VAT, you have a state VAT, and you have some sort of state federal excise tax. So what's the scenario today in relation to Mercosur? Mercosur was created in 1991 by the Assunção Treaty, and it was conceived as a free trade zone, and at that time was an illusion that we can move forward to economic union like in European Union. This didn't happen. The Mercosur, in the end, it can be said that Mercosur is a failure. And why is a failure? And I give some examples on that. First of all, we have very different economic views and situations among the countries in the region. For instance, I like to give this example: Brazil and Chile. Chile is a country with 9 million persons. It's a population of 9 million, and 95% of the gross product of Chile comes from the mineral sector. So what's the approach of Chile? Chile wants to have a free trade condition to approach all the markets in the world. Chile, within the mineral sector, Chile is by far the biggest producers of copper. Chile produces 80% of the copper in the world. So in the case of Chile, it's not a matter, it's not a concern for them to have tax incentives to one specific sector to protect their industry, because the main industry in Chile is very strong worldwide. What's the view of Brazil? Brazil is one of the most protectionist countries in the world. Why we are protectionist? Because like China, not so big as China, but we are a big country. We have more than 200 million persons in the country. And so in the end, we like to protect our industry. It can be said in terms of more liberal, not liberal in terms of tax incentives, but liberal in terms of economics. It can be said that we can move to a different scenario, but the fact that today we have this approach. And then in this case, what happened in the case of Brazil, we protect the hydroelectrical plants, we protect our oil and gas sectors. In the last years, the production of oil and gas in Brazil increased a lot because a specific area in Rio de Janeiro basin was found. It's called the pre-salt area, and Brazil granted a lot of incentives in terms of oil and gas production. As I said before also, Brazil and Argentina are federations. Constitution grants tax-relevant tax powers to its states and municipalities, and this is a problem for itself. I don't have too much time, and so I have to skip for the last slide and to my conclusions. And in this scenario, how are the incentives and for the energy sector in Mercosur and Brazil, and how is this relation with an environmental approach in relation to green taxes? We don't have, like Sweden or other countries, a framework of green taxes or incentives. We have a lot of them. For sure, Brazil has some concerns in relation to environmental. We have this ethanol approach. We have other incentives for other energies, but we don't have, both in Brazil, in Argentina, in Paraguay, and other countries, a very well-defined set of rules in relation to green incentives. At the same time, that you have this melting pot. What's a green tax? And this was discussed yesterday. If I'm not wrong, I remember Rafaela saying that in the end, a green taxation or an incentive to a more environmental friendly atmosphere is the one who encouraged more consumption on energy green taxes. I don't know if this is true, because I'm going to give an example, and this comes when Marta and Javier, they called me, I think that just 1 week before we are supposed to finish the paper to the book. And then I was going to check the case of in the WTO about green subsidies or green subsidies. And if I'm not wrong, from the 4 cases, 3 of them was about the production of solar panels. Thanks, Alice. Solar panels. And in the end, this is not a green subsidy. Why? First of all, I think that one of the cases of India, and the case of us is just about how India could explore some advantage to produce solar panels in China and export solar panels. I don't know if China has some a green framework for taxation, but in my mind, this is not a green subsidy or something to encourage green taxation in the country. And then you have this whole pseudo green taxes, and then I think that you have to balance that with real measures that can be implemented in one country. And for that, and trying to go to my conclusion, besides all these taxes or green incentives that you have in Brazil, and for some extent, I think that I approached this yesterday, I think it's very important to have different approaches on how to induce a green consumption or a green attitude in relation to energy. I think you can give tax incentives. I think that we can subsidize some undertakings. But one thing that I think is the best example that I can give in Brazil is the so-called ecological VAT. What's the ecological VAT in Brazil? And then we have very bad things in the country, but this is one thing that really works in Brazil. 25% of the state VAT, which is the most important tax in Brazil, go to the municipalities, no? And 5% of these 25%, they are granted to the municipalities which have the good projects in terms of green projects. I mean, if one municipality introduce a more green consumption of for public transportation, for instance, you have a federal commission that can evaluate this project, and in this case, this municipality can increase its share in the revenues of VAT. I think this is a very good approach. I think it's a very good measure. It works in Brazil. And in the end, I think that the most important thing on that is not because we are here to discuss any kind of measure in relation to or towards green taxation. I think that we are talking about public resources, and then I think in this case, I think the most important thing is to have also a green taxation, but with efficiency and consistency. Thank you.
Sorry for cutting your time, but it seems that for Brazil, between WTO and Mercosur, rigid and flexible policies, it's time for choices. And also, from the constitutional point of view, apparently. Well, the floor is now to Professor Michael Skov Andersen from Denmark of the Aarhus University. He's Professor of Environmental Policy Analysis, and he has also been working with the European Environmental Agency in Copenhagen. The floor is to you.
I think the EU state aid guidelines, they are actually quite brief and simple when you compare with the financial guidelines for managing EU projects. And everyone who's been in those shoes knows what it takes. So I will also express my gratitude to Marta Villar for taking up the leadership of this project, and also to your colleagues for all the support offered to this workshop. But the topic for my talk here will be about the issue of border tax adjustments. I come from a small country, at least a small country in terms of population size, and we have had for a long time carbon and energy taxes in place. So I think we put these instruments in place in the hope that more countries would join the club of carbon pricing. But as I will show you here, the developments haven't really progressed as fast as we had hoped for. So the overview here is, first of all, what I will address here, what is required actually in terms of carbon pricing in relation to climate mitigation. What does the IPCC has to say about this? Also the global overview, how far have we come on carbon pricing? And then this issue of border tax adjustment, what does it imply? This leads then to some concerns related to trade-intensive and energy-intensive industries, and the question about how sensitive they are. And in relation to emissions trading with free allowances, which are often offered to these energy-intensive industries, I think there's an important question that comes up about the windfall profits that can be related to such free allowances and whether that actually qualifies as state aid. And on basis of this, I will offer then some observations and conclusions. But as I said, we are a small country in terms of population size, not in terms of territory, because Denmark includes Greenland, and you can say Greenland is mainly ice and snow, but also we would like it to remain that way. And so the challenge there of climate change is a big one, actually. This photograph here is from Hurricane Katrina. I think there 10 years ago that provided an impetus to some new developments, but they are perhaps fading out a bit since we had the Stern Review. we had also at that time quite strong statements from European Commission President Barroso about the need for carbon pricing. The IPCC has also looked into the question about carbon pricing, and at that time considering less stringent mitigation targets, the IPCC suggested that we would need a carbon price at least at 15 to 20 euros per ton of CO2 by 2020, just to achieve a 550 ppm target. But it's clear that for those more stringent stabilization targets, which are also part now of the Paris Agreement, to aim for 2 degrees or aim perhaps even for 1.5 degrees, the implicit carbon price required is much higher and more likely to be around 30 to 40 euros per ton of CO2. And also the IPCC stresses that the carbon price will need to increase, to keep increasing in real terms to be able to achieve the reduction in the use of fossil fuels. So at the time of the Copenhagen, the COP in Copenhagen at the end of 2009, we had prospects there of carbon pricing in terms of emissions trading systems materializing in many regions around the world. The EU was the first region to introduce emissions trading, but Australia also introduced an emissions trading system, and New Zealand as well. Emissions trading has then been under discussion and is still under discussion in many other regions in the world. Mexico is moving towards emissions trading, and we have a regional scheme in the US, the REGI scheme. South Korea is moving towards emissions trading. But there's been a lot of talk and so far very limited action. And unfortunately, Australia last year repealed its emissions trading system. So in fact, if we take a more sober view of where we stand today, we haven't achieved a lot since 2010. Many policies are still in the pipeline as regards emissions trading. There's been somewhat more progress on carbon pricing with taxes, because a number of countries have introduced carbon taxes. Japan is one of the more notable countries now to have introduced a carbon tax. So when we consider there the global emissions of greenhouse gases, the World Bank here provides an overview of the coverage of carbon pricing in relation to CO2 emissions, and so the coverage still is only about 12 to 13% of the global emissions. By the way, you can see here the Chinese pilot schemes, that what coverage they have, and I should have mentioned that before, that perhaps that's one of the most important measures, is that these pilot schemes were introduced in 2013. But there are emerging schemes of carbon pricing on the agenda, and I think also for the countries that were here presented in the panel, and I'm not the kind of expert that I can give you the complete up-to-date picture of it, but only to say that there was this very promising announcement of the Chinese ETS, which was also mentioned in the presentation we heard yesterday, that China will launch a nationwide emissions trading system by 2017. But what does emissions trading do? Well, it imposes a penalty on the emissions, quite similar to a carbon tax, especially then when certificates are being auctioned. And when there is auctioning, there's also some revenues which can be recycled, and they can be used to mitigate the impact on competitiveness if other distorting taxes are reduced. And the standard case is there to reduce taxes on labor. But a challenge remains nevertheless for energy-intensive industries, because these energy-intensive industries are usually less labor-intensive. So even with some revenue recycling, they will not be fully compensated. And also without like penalties on emissions abroad, the competitiveness of these energy-intensive industries will be likely to suffer, and that's exactly the argument then for resorting to grandfathering, so the handing out of free allowances for energy-intensive industries. But another option would be to consider to price those emissions and then to introduce a border tax adjustment. So there's a case there for protecting the price signal from the pricing of carbon with auctioning. And the basic principle behind a border tax adjustment is very simple. It means that tax rates are adjusted at the border so that exports are rebated by the amount of the tax they bear, and imports from untaxed foreign competitors are being taxed equivalently. This enables a country to tax, and I'm talking here about tax in the broad sense, also involving pricing of CO2 emissions, to tax domestic industry for internal purposes while preserving its competitiveness internationally by allowing its exports to compete untaxed in the international markets, and then domestically by taxing imports to the same degree. And this is not really, it's not rocket science, this border tax adjustment. It's something that happens every day in many different areas, including for petrol, cigarettes and alcohol. So the question is really, can we extend this mechanism also for carbon and for pricing of CO2? We have seen here that we have the European ETS, and we have seen also that we have several countries in Europe that have CO2 taxes for non-ETS emissions, and also in any case that the non-ETS sectors are subject to EU energy taxation. So I think it's relevant to discuss this exactly in the context now where the whole emissions trading system is up for revision, and there's discussion about the future of the emissions trading system. But many concerns can also be raised over border tax adjustments, and I think we can group these into legal concerns, political concerns, and economic concerns. I think the legal concerns have already been under discussion for a long time. There's a lot to be said here about WTO requirements, but the argument is being made that there is in certain case decisions, certain precedents to allow border tax adjustments, and often here the GATT Superfund case is being mentioned in this relation. And this whole discussion is very nicely captured in a not so well-known publication by the WTO Secretariat jointly with UNEP that was published in 2009, where the WTO Secretariat describes how there's a potential for WTO conformity allowing actually for border tax adjustments. So I think that if there was a political will, it seems that it would also be possible to find a legal way. But nevertheless, there are political as well as economic challenges too, and we have seen when the European Union extended its ETS to international aviation and hence also introduced pricing for foreign flights, the kind of reaction that came from major regional powers, including China and the United States, that this pricing scheme came under heavy fire. So it's clear that if you want to do something like this, to go along with border tax adjustment, it has to be accompanied by a very active diplomacy to explain the measures and to negotiate its acceptability. And we may also raise questions about economic feasibility and whether such a border tax adjustment will really address the issue of carbon leakage sufficiently. Because once this arrangement is being introduced and there is a price for carbon internally in the European Union with full auction, more or less full auctioning of allowances, there will be some carbon leakage remaining because there will be then an effective price for production within the European Union. And also in economic terms, it's often being questioned, is there a risk for a real trade war if the European Union pioneers some kind of border tax adjustment? So we need to consider here more carefully this issue of how far to extend this such border tax adjustments. And I think I would argue that the case for an across-the-board border tax adjustment involving all emissions is probably not very strong, whereas we might want to consider this for particular sectors, and we want to identify then which sectors are really trade intensive, because being energy intensive is not necessarily the same as being trade intensive. And this has been mentioned also previously, I think, in this conference, but I give you here the final results from a large econometric analysis that was done in a previous EU-funded project on basis of historical data, which tried to sort the different industrial sectors according to their relative energy intensity and trade intensity. And what came out of this analysis is that there are certain sectors, such as the food provision sector, which is both less energy intensive and also less trade intensive. There is also a sector such as non-metallic mineral products, which include cement production, which indeed is very energy intensive, but it's not being traded very intensively across borders. So probably the strongest case for concerns about trade intensity is really with the steel and the iron and steel industry, the basic metals, and perhaps also to some extent the chemicals. So really the dilemma we have in global climate mitigation policy is that these energy intensive sectors account for a very large share of the emissions, while they contribute only to a limited extent to GDP. And I jump further on, because this has been discussed, and I wanted also to bring this to your attention, that actually this whole idea of border tax adjustment, it's not just a theoretical construct that I'm putting forward here for the workshop, but there's actually a recent about 1-year-old resolution that was passed in the European Parliament exactly about the steel sector, which requested the European Commission to look into this topic of a border carbon adjustment. And in this European Parliament resolution on the steel sector, yes, concerns were expressed about the competitiveness of the steel industry in view of recent global developments in the sector. And as one way forward, the Parliament proposed to introduce such a border carbon adjustment. So it will take some diplomacy. It could generate some revenues that could be used, and hopefully if this was brought into the discussion, it might also help provide a push or a trigger to other regions who are thinking about emissions trading. But let me close this presentation by providing yet another perspective on the issue, because the drawback of emissions trading when there is not full auctioning is that there are some windfall profits involved. And I think this was mentioned also in the previous panel, that these free allowances, they do have a value. And industry, which is profit maximizing, will of course try to pass that value over into the pricing of their products. And there was one study here that was released only 2 months ago, which argues and tries to show with the econometric analysis how European industry actually has made a large profit of more than 20 billion euros from the over-allocation of free allowances. So where are we in the relation to the discussion about state aid in this discussion about the value of the free allowances? There are legal experts who argue that this also amounts to some state aid, and actually that the European Union has failed to notify, as it is required under WTO rules, about this state aid. So to conclude, I would say that border tax adjustments, I think it deserves more careful consideration, and I think it will be interesting to see how the Commission will respond to the resolution from the European Parliament. I think it's especially relevant for certain industry sectors that are highly trade intensive. It's not something that will be feasible across the board for all CO2 emissions. And if we can expect other regions in the world to gradually begin to introduce emissions trading, perhaps also starting with some free allowances, as has been the case in the European Union, I think there will be some important issues to consider there regarding state aid, because there will also be some windfall profits falling to industries in those regions. And here I think we must say that the EU is perhaps not in the best position to complain about this, because the EU itself has failed to notify the WTO about the implications of its own emissions trading system.
Thank you, Professor Skov Andersen, for your useful information about the international or European data. With you, we shifted from individual, though important, country cases to a more general perspective. The floor is now to Dr. Alice Pirlo de la Université Catholique de Louvain. She is going to talk about WTO and state aids.
So first of all, I would like to thank Professor Viard and Professor Pistone for the organization of this conference and the leading of this research project. It was really interesting projects for 2 years, and I'm really happy I can be here today. As you've seen in the program, and as you can see from the slide, I'm going to speak about energy tax reliefs in light of EU state aid law and WTO law on subsidies, which has already been a little bit mentioned by the previous speakers of this session. So now you may wonder why I chose this picture to introduce my presentation. You probably know this game. The idea is to spot the 7 differences between 2 drawings, and for those who started to search, here's the solution. But most importantly, I chose this picture because this game pretty well represents what I've been doing the past weeks for preparing this conference. My main task was similar. I had to spot the differences between EU state aid law and WTO law on subsidies as far as energy tax reliefs are concerned. And by energy tax reliefs, I refer to all fiscal mechanisms which directly or indirectly provide for preferential treatment in favor of energy products or in favor of the energy sector. As in the game of the 7 differences, the 2 legal regimes seem to present many similarities at first sight. But when you look closer, you can realize that they actually differ from each other. From a legal perspective, this comparison is important for 2 main reasons. First, it's important because the comparisons allow us to determine which of the 2 legal regimes the best deal with energy tax reliefs. But it's also important for the EU member states, because if an EU member state decides to adopt energy tax reliefs, this energy tax relief should not only comply with EU state aid law, but also with WTO law on subsidies. And if the 2 regimes are different, then it means that there are additional requirements for the EU member states to comply with. So my main objective for the next 10 minutes is to identify the relevant points of comparison between the 2 regimes for the specific case of energy tax relief. But before I go on with these specific points of comparisons, I will first briefly come back on the 2 legal regimes from a general viewpoint. There has been various general comparisons in the literature. I can quote some of them, one by Luja, one by Claire Michaud, sorry for the pronunciation, one by Luca Rubini, and also by Pernie Wegener-Jensen, who is now here, and who was also part of the research project, and her analysis was really useful to see the main differences between the 2 regimes. You can compare those 2 regimes from different perspectives, and the first one would be the general context. When you look at EU state aid law, the main objective is the protection of the internal market. When you look at WTO law, the main idea is to protect international undistorted free trade. Now, as far as the scope is concerned, when EU state aid law is concerned, not only goods, but also services fall into the scope of Article 107 of the Treaty on the Functioning of the European Union, and so on. But when WTO law is concerned, mainly goods are concerned. You could also say that the GATS, the General Agreement on Tariffs and Services, also concerns subsidies on services, but the regulation is less strict. When we look at the substantive rule, you all know that the main legal ground for state aid is Article 107 of the Treaty of the Functioning of the European Union. For WTO law, it's the Agreement on Subsidies and Countervailing Measures. The main legal grounds, also some provisions in the General Agreement on Tariffs and Trade. And we could also refer to the Agreement on Agriculture, to a certain extent. So those rules provide for the main legal elements that define what constitutes state aid or a subsidy under EU law and under WTO law. I will not go into the details of those legal elements because you probably all know them and we've been discussing state aids for 2 days now. But I would like just to say that they present many, many similarities when you look at those different legal elements. Now, as far as the procedural rules are concerned, for EU state aid law, you have this notification, the approval by the European Commission, so you have an ex-ante review. At the WTO level, you also have this notification requirement, but there is no real sanction. So, for example, for the case of the EU ETS, that the European Union should have notified. I'm not saying it should have, maybe it should have. I don't want to blame the EU too fast. There is this requirement, but there are no real consequences. And if a WTO law member finds that another member has adopted subsidies which would contradict some provision, he has two options. First, he could decide to act at the WTO law level, and then a panel could assess the compatibility of the potential subsidy with the agreement on subsidies and countervailing measures, for example, or he could act at the individual level and take action at the national level by adopting countervailing duties. What's also interesting is that at the WTO level, you have this strong political character, so you see many disputes that ends with a mutually agreed solution. So this is important because it's much less systematic than at the EU level. Based on this general comparison, I would like now to put the emphasis on energy tax reliefs. And I believe that there are three main points of comparisons between the two legal regimes with regard to energy tax reliefs. A first point of comparisons concern the general legal framework surrounding energy tax reliefs at the WTO law level and at the EU law level. When you look at EU law, you all know that we have those common rules, the Energy Tax Directive, the Directive on the Promotion on the use of renewable energy sources, etc. And all those rules will influence the way member states may or not tax energy sources, energy products, the energy sector. In contrast, at the WTO level, you don't have any specific agreement on energy issues. It means that basically energy issues are dealt with general agreements. The general agreements. So, for example, the general agreements on tariffs and trade or the agreement on subsidies and countervailing measures. This is the first general point of difference as far as energy issues are concerned. But now I'm coming with two specific points of comparisons which I think are very important to compare the two regimes with regard to energy tax relief. The first one concerns the exemptions. As you all know, and it has been pointed out by many of the speakers in the last 2 days, at the EU level we have this exemption provision in the General Block Exemption Regulation. It can be criticized, it has been criticized, and I largely agree with the criticism, but this is the first big difference with WTO law, because you don't have any similar provision at the WTO law level. And this means that some so-called approved measure at the EU level could fall under the control of the agreement on subsidies and countervailing measures and may be found incompatible with WTO law. So EU member states should pay attention to this first difference. A second difference is the balance with environmental objective that we have at the EU level. My friend Estela Ferreira was presenting some cases yesterday, also Professor Del Federico. and so on. And you can really see that at the EU level, you have this balance between the negative effect of a potential incompatible state aid and the positive effect on the environment. We also have the guidelines, which set some guidelines, some rules to be followed by the member state in order to adopt compatible measures in favor of the environment. At the WTO level, usually it's said that there is no such balance as far as the agreement on subsidies and countervailing measures is concerned. But still, I'd like to bring 3 nuances. The first one is one of the article within the agreement on subsidies and countervailing measures, which is now no more into effect. It's Article 8. And this article concerns non-actionable subsidies, meaning that this article was, okay, I'm going fast, meaning that this article was giving a WTO member the possibility to adopt some favorable measures for specific objectives. For example, in order to promote certain sectors that needed to adapt to new environmental regulations. This article is no more into effect, but some authors argue that it should be taken into account in the interpretation of the agreement on subsidies and countervailing measures, in order to interpret it in a green way. Another argument is GATT Article 20, which is the general exception article, where you can find some provisions in favor of the environment. I personally believe that it wouldn't apply to the agreement on subsidies and countervailing measures. And the third argument is a recent case, a recent dispute at the WTO law level concerning feed-in tariffs for Canada, in Canada. And it was considered by some other WTO member contrary to the agreement on subsidies and countervailing measures, but the panel, an appellate body, found that for assessing whether there was a subsidy or not, you should take into account the specific features of the renewable energy sector. And you could read this case as one sign that the WTO is open to some policy consideration regarding the renewable energy sector. So these are 3 nuances to say that also at the WTO level, you could take into account policy considerations. I'm now coming to my conclusion, 2 small remarks. First one, I didn't really assess which of the 2 regimes was the best regarding the taking into considerations of environmental perspective. I would say that at least at the EU level, you have some specific regulations, some specific rules, which could be considered as a sign of more legal certainty, even though we've said before that legal certainty is certainly not perfect at the EU level. And the second remark, I really believe that EU member states should pay attention to WTO law on subsidies when they adopt energy tax reliefs, because EU state aid law is not the same as WTO law on subsidies, so there will always be a risk for EU member states to adopt such measures without taking into account WTO law surrounding subsidies. Thank you very much for your attention, and sorry that I was so fast at the end.
I regret again being compelled to cut short the last 2 speakers. Probably the international part of the session was somehow a way to complete the discussion about individual country cases. I received suggestions by the organizers not to give the floor to a question time. I understand that we ran out of time, so that I want to thank again Marta Villar and the other organizers. Personally, I learned a lot from these 2 days of work, and I declare closed the session.